Namaste Sadavatsale Matrabhume. I am here to talk about the Subuku Shankar case. Subuku Shankar is a famous YouTuber and he do not having more subscribers. He having an 8 lakh and 5,000 subscribers, but his reach is very broad in the Tamil Nadu, especially from last 2 or 3 years when Subuku Shankar is exposing the game of the DMK government, the corruption of the DMK government, irregularities of the DMK government, and the policies of the DMK government. That is why the DMK government of the Tamil Nadu is against Subuku Shankar and arrested 9 times since last 2 years. 9 times they arrested Subuku Shankar. Every time Subuku Shankar got the relief from the court, either from the High Court or from the Supreme Court. But the government of Tamil Nadu is against Subuku Shankar, the freedom of speech and expression. Before starting to the Subuku Shankar case, I want to remind the cases of Supreme Court or cases about the press under Article 19(1)(a) read with Article 19(2) of the Constitution of India. When we are talking about Article 19(1)(a) means freedom of speech and expression, but it having the reasonable restrictions under Article 19(2), like you cannot talk against the sovereignty, against the public order, against the decency of the government, defamation of content of anyone, and contempt of court. These are the restrictions on the freedom of speech and expression. Especially, we must have to keep in mind that the media do not having any special right about the freedom of speech and expression. Whatever the right we have, whatever the right the citizen of India having in our country to speech and expression, the media having the same right. Media is themselves coding them that they are the fourth pillar of the democracy. It's not it can be said by the media, but fourth pillar of the democracy is the people of India, or the main pillar of the democracy is the people of India, and people of India having a right to speech and expression. They can talk about whatever they think fit, but cannot talk in the way whatever is restricted by Article 19(2), like sovereignty, public order, decency, defamation, contempt, or anything else that is against the public morality of the country. Before deciding this, we before coming to the Subuku case of Tamil Nadu, we have to discuss few famous cases in India. That is the Ramesh Thapar case. The first case in India was the Ramesh Thapar, where the pre-censorship was applied by the Nehru government at that time. Actually, Ramesh Thapar's articles or his matter was the communist matter. He was the communist leader. I think that is why there was the pre-censorship. On the Supreme Court said without publishing anything, you cannot imagine, you cannot surmise that the person who is going to report will be against the country. That is why the pre-censorship is unconstitutional. The famous case came in 1958 when the newspapers versus Union of Express newspaper versus Union of India issuing Working Journalist Act fixing wages challenges as restricting press freedom. Honorable Supreme Court at that time said that the economic regulation are permissible, but they do not cripple the right of press, the right to know with the people. Another important case was the Sakal Papers versus Union of India 1962, where the newspapers price and page act was passed by the Nehru government, and restricted by this act the pages and prices, that on the basis of the pages and prices there may be the rate for the media. Honorable Supreme Court at that time said struck down this act as it indirectly limited circulation and advertising revenue. So Supreme Court said not only the freedom of speech and expression, not only the content, but the circulation is also covered by the economic right of any newspaper is also covered by Article 19(1)(a). Bennett, Coleman and Company versus Union of India, the very famous case in 1972, of the Supreme Court that time declared unconstitutional as press freedom. Supreme Court said press freedom include freedom of circulation and volume of the contents, No indirect restriction can also be imposed. No direct or indirect restriction can be imposed. Another important case was Indian Express Newspapers versus Union of India 1985. That was the high custom duty on newsprint. Supreme Court said differential duties burdening press are unconstitutional if aimed at suppression. Taxation or duties cannot be used as a tool to control the media. So there is a lot of cases and important was Secretary Ministry of Information Broadcasting Cricket Association of Bengal 1995 broadcasting rights and government monopoly on airwaves ruling. Airwaves are public property, means if I want to see the cricket match of Indian team, then we have a fundamental right to see, right to speech and expression includes right to view and know the performance of the country. That is why the government cannot monopolize right to telecast a sports event to any one company. Reasonable regulations of the spectrum allowed, but not monopoly. These are some important cases. Right now, Subuku Shankar, was who was arrested 9 times and every time get the relief from the court. We have another matters also of the same type. Subuku Shankar, that another was the Arnab Goswami, and was the Vinod Dua case. Vinod Dua was against the Vinod Dua. There was the FIR in the Himachal Pradesh because he was talking about the Prime Minister of India's policy, means policy of the central government, the policies of the government. That is why there was the case on the Supreme Court say criticizing the policies is is not covered under Article 19(2). When you are talking about Article 19(2), if he is in the danger for the integrity of the country, he is danger for the security of the country, he is danger for the morality of the country, he is danger for the defamatory content against anyone. If not, then the freedom of speech and expression is absolute, not absolute, but except these, he have an absolute right to talk about. Subuku Shankar case, we are coming on the Subuku Shankar case. What happened about the Subuku Shankar? Subuku Shankar is a Tamil Nadu YouTuber, whistleblower known for the exposing corruption in Tamil Nadu, especially DMK government and police. He was arrested 9 times in 2005, 2029th time in 2025. Main issue that was prevailed in our country was in 2024. Ali's derogatory remark on women police officer in an interview invoke Gunda Act. Gunda's Act Prevention of Detention law was applied. And the Supreme Court said that if you are scared by any statement of any one people, any one person, that is not correct. That is why if he is exposing, he having a different view, and that view is against the government, does not mean that he is liable to be arrested. He is liable to be to be restricted. In Subuku Shankar case, Honorable Supreme Court said that if you are not agreed with his view, disagreement with the view of the policies is the fine base of the fun of the democracy. In democracy, some people having them different views, some people may criticize it, some people may say something, some people may have their own views. If any person is giving their own views or criticizing the government policy, then you must have to satisfy them, you must have to explain them, you must have to do the work finer than this time, but you cannot arrest that person. Supreme Court decided. Now in Subuku Shankar, in this case, Subuku Shankar were arrested, his mother gone to the High Court, and she played to the High Court that the Subuku Shankar is the heart patient and he is a diabetic. But even though again and again arresting that person in 1 or 2 months by the state government is not good. Honorable High Court said that if you are not agreed by the words of the Subuku Shankar, you may file the case, civil suit against him. You may expunge his video, you may expunge his statement, you may file the case in the civil suit, but every time you are arresting under the criminal laws is not good. You cannot arrest any person in the criminal law. even though I know well that that any person who is an influencer, or who is an journalist, does not mean that he having a power over than any right that the fundamental any right the person have, but can't. Like, but there may be some restriction that we knows that the Muhammad Zubair, Alt News 2025. He was the co-founder of the fact-checking site Alt News, but his intention was to disturb the harmony or the religious harmony. He has given a statement in religious sentiment of the country. He has given a statement against the Nupur Sharma, the spokesperson of the Bharatiya Janata Party. That is why he was arrested at that time, even though, because it was covered by Article 19(2), so High Court has given him that bail. Court has given the bail. In the Sadiq Kappan case, he was the Kerala journalist traveling to cover the Hathras rape case, arrested under UAPA for alleged PFI link and sedition, because he had the PFI link. He was funded by the PFI. He was here for the sedition activity against the country. That is why he was arrested and covered by Article 19(2). Even though Honorable Court has given him the bail, I want, here the matter is simple, that you cannot arrest any person. Subuku Shankar is the person who was exposing the main corruption of the DMK government. He was exposing the policies of the DMK government. He was exposing the lot of things of the DMK government. That is why the DMK government has arrested him, and he was doing every time was trying to arrest, to humiliate him. That is why High Court has given a hard comment on Subuku Shankar's arrest. I think that the state government of Tamil Nadu must have to listen that and have to do the work as per the Constitution of India. Thank you very much. Jai Hind, Jai Bharat, Vande Mataram.